Good morning, everyone. Hi. So, today, my talk is an introduction to the Hong Kong legal system. Now, I begin by explaining that this is actually quite a big ask, because my book on this subject runs to 600 pages, and it's for law students, and you're not law students. We normally, in a lecture course, devote about 50 hours to the subject, lectures and tutorials. Today we have 1 hour. So I have to be very selective, and I'm going to concentrate on the key themes of the legal system. There'll be plenty of stuff that I miss out, but I'm going to focus on what I regard as the most important aspects of the Hong Kong legal system. So, the key themes. First, Hong Kong has a common law system, and I'll explain in some detail what that means later, and Hong Kong is different. So, common law systems. Most legal systems in the legal world are either civil law or common law. I'll give you a quick example for now. France, Germany, Western Europe, and China have civil law systems. I'll explain what the difference is later. Common law systems derive originally from the English common law, so England, Australia, New Zealand, Canada, United States, sort of. Okay, broadly, civil law systems then are found in Western Europe. They originate from Roman law more than 2,000 years ago. So it's a much older system. As a matter of interest, China adopted a civil law approach. Its major influence, in fact, in the modern Chinese system is probably Germany. Common law systems derive from the English common law found throughout the whole country. So almost all common law countries were once British. English common law. Why is it called common? It means it's common to you, wherever you are in the country. Simple as that. I'll give you a little bit of history. Before that, we would have local courts that would have one set of rules, and then a local court somewhere else in England which would have a different approach. Some markets had their own rules, and so on. But the English kings decided we should have common law everywhere, and people should come to the king's courts. The same law would apply everywhere in the English kingdom. And why were the kings so keen on this? Because having a court meant money. People come to court, they pay for the privilege, and therefore this is money to the crown, as it were. So, let's look at a map. How good are you at your geography? So I'm going to test you. Where's this? Australia. Okay. And notice, darkest, it's a common law system. Of course it was British. Okay. North America, here we've got the US and Canada. Again, common law systems. India, once British, Pakistan, Bangladesh, all originally British, they've got common law, and so on. Notice, even this half, this is the biggest island in the world, New Guinea. On that half belongs to Indonesia, so it's got a civil law system because Indonesia was once Dutch. This half, common law, because it was, for a while, Australian. Okay, look at South America. It's all civil law, because South America originally belonged either to Spain or Portugal. Quiz question for you. What's the most common language in South America? Spanish is a very good guess, but technically, because it's a tricky quiz question, the answer is Portuguese. Because although all these countries speak Spanish, this one speaks Portuguese. It's Brazil, it's huge, it has a huge population, and there are more people in Brazil than the rest of South America put together. Notice this little chunk there, that's Guyana. It used to be called British Guiana, and therefore that's the only bit of common law in South America. One last thing before we move on. Notice that some are a bit of each. This bit here, you probably don't know, is called Louisiana. And Louisiana was actually bought by the United States from France in something called the Louisiana Purchase. Because it was once French, there's a little bit of civil law there in this big common law sea of North America. And this bit in Canada, any thoughts? Anyone know much about Canada? This bit is called Quebec, and it was French. And when the British took over Canada, they allowed the French to keep their language, their customs, and their law. So that bit has common law and civil law. And lastly, down here, Namibia, South Africa, they've been both British and Dutch and German, so there's a little bit of both. So that's a little introduction for you. Of course, there are places which have neither a civil law or common law, but most of the world's legal systems are one or the other. I've already told you that Hong Kong is special. It's a common law system which it inherited from Britain and which is guaranteed to carry on under the basic law, but it's floating in a sea of civil law. So here, you know, little Hong Kong in enormous China, and yet Hong Kong common law. Another, it's the only part of China that has a common law system, and in the whole world, Hong Kong is the only place that has a common law system but uses Chinese in the courts. Not exclusively, but for example in Hong Kong, law reports are written in English and Chinese. Many court proceedings, especially in magistrates' courts, are held in Cantonese now. But that's all very well. But you all know that Hong Kong was reunified with China in 1997. Why has Hong Kong kept the common law system after reunification? The answer is to be found in the Joint Declaration and the Hong Kong Basic Law. Now, we're moving a little bit into politics and the constitutional framework, but it's necessary to understand the legal system. So, there was the Joint Declaration signed. What did it say? I'll give you a little bit of the background. Why did we have this joint declaration? Why did we have negotiations between Britain and China? What happened in the 1980s is that people started getting nervous. They said, you know what, there's a handover in 1997. What will happen to my lease? People are very concerned about land and houses and their flats in Hong Kong. If I've got a lease in the new territory, which is normally going to be for 50 years, and I sign it in 1980, what's going to happen in 1997, only 17 years later? And such was the anxiety that even though Deng Xiaoping, the then Chinese leader, said, don't worry about this, put your hearts at ease, we will honor these leases. But people were nervous. And so the British, not the Chinese, the British asked, can we have talks about the future of Hong Kong? And Deng Xiaoping, the Chinese leader, and Mrs. Thatcher, the then British Prime Minister, had talks, and the outcome was that a joint declaration was signed. These are the key points. China developed a 12-point plan. Hong Kong could retain its existing legal system. Okay, so that's why we still have a common law system. It would have its own court of final appeal, but no armed forces. The 12-point plan was rather vague. We needed to fill out the gaps. It was just what we would call skeletal. These are the main points, but there's not a lot of detail here. The British made some proposals that the Court of Final Appeal could invite judges from other common law jurisdictions, and they've been doing it ever since. Why was that important? Because before the Court of Final Appeal was set up, the final appeal through the Hong Kong courts went to the Privy Council in London. Of course, that's not going to happen anymore. So we need our own Court of Final Appeal. But no Hong Kong judge had any experience of ever being a final appeal judge, because they'd previously, the highest they could reach was Court of Appeal, and there could be an appeal from that. So it was thought we need people with experience of being on the final court. And that is the rule, that although we have overseas judges in the Court of Final Appeal, it's only one per court, maximum, and those judges must either be serving or have served in the highest court in their own country. So, the High Court of Australia, the UK House of Lords, now the UK Supreme Court, and so on. The Canadian Supreme Court. The Joint Declaration laid down the blueprint for Hong Kong after 1997 as a special administrative region of China. Paragraph 3 said that Hong Kong would have a high degree of autonomy, responsibility for internal law, run its own finances, have a separate currency governed by local inhabitants. It would be governed by local inhabitants, and the existing rights and freedoms would be preserved except for defence and foreign affairs. And a guarantee that there will be no change for 50 years. So now people say, what's going to happen in 2047? Where did the 50 years come from? Many people believe the Chinese said only 50 years, but actually that wasn't the case. Deng Xiaoping said, if one country, two systems is working, why don't we keep it forever? The British were concerned forever might be not too precise, so they wanted a guarantee of at least 50 years. That's the background. Okay. High degree of autonomy, responsibility for internal law, running its own finances. Now, you know, there are very, very few non-countries in the world, and Hong Kong is not a country that have their own currency. Hong Kong has its own dollar. And even weirder, that dollar is pegged, but not to the Chinese yuan, but to the US dollar. Very weird. And maybe, given that the US dollar is not doing too well, it's possible that Hong Kong is thinking of getting away from that peg. The reality is Donald Trump is ruining the US economy, and dollar is diving. 3 years, all-time low. So, all right. The declaration was formally ratified on the 27th of May, 1985. Paragraph 1 says, China has decided to resume the sovereignty over Hong Kong with effect from 1 July 1997. So, it was signed in 1985, and the idea was that for the next 12 years, Britain would continue to administer Hong Kong, but with the knowledge that it was going to revert to China in 1997. Britain would restore Hong Kong to the PRC. There was a need for a basic law to incorporate the provisions of the Joint Declaration. I've told you the Joint Declaration not very much detail, we need much more. And we got it. So paragraph 312 said, the above stated basic policies regarding Hong Kong and the elaboration of them in the joint declaration will be stipulated in a basic law of the Hong Kong SAR. And what is laid down in the basic law will remain unchanged for 50 years. Quick word on the fact that there was a difference of opinion, which has led to some later political disputes. The British said the joint declaration is a treaty, although the word wasn't used, it was called a declaration. It's a treaty signed by two sovereign states, and each of us has an interest in its being implemented. So occasionally the British will say, China is deviating from the joint declaration. China's view is it's now been replaced by the basic law, a piece of Chinese legislation, and they say the joint declaration is just a historical document. Has no binding effect at all now. The governance of Hong Kong is entirely a matter for China. So, notice what I've bolded, however. Still, both parties recognise that the bare bones of the joint declaration will be replaced by Hong Kong's basic law, which has over 160 articles, plus annexes, plus interpretations. And there it is, a piece of PRC legislation, but a fundamental source of Hong Kong law, created as a basic law of the PRC and Hong Kong's mini-constitution. Why do I say a basic law, small b, small l? Because China has a number of fundamental, special or basic laws. Hong Kong's basic law is just one of that group. Despite the 160 articles plus annexes and interpretations, I will focus only, or primarily anyway, on Articles 1, 2, 8, and then 82 to 86. Okay, that's quite selective, but these are, for me, the key to understanding Hong Kong's modern legal system. These establish the post-1997 political reality for Hong Kong and make clear its continuation as part of the common law family. So, Article 1, the Hong Kong SAR is an inalienable part of the PRC. This sets the scene straight away. Hong Kong is part of China. We might give it a high degree of autonomy, but it's part of China. Article 2, the National People's Congress authorises the Hong Kong SAR to exercise a high degree of autonomy and enjoy executive, legislative and independent judicial power. That word independent doesn't relate to the executive, you know, our chief executive and his advisors. It doesn't apply to the legislature, to LegCo, but it does apply to judicial power, independent. So, the reality then is that Hong Kong has returned to China, but is different, not least in being guaranteed an independent judiciary. The PRC doesn't have an independent judiciary and officially states that it does not have an independent judiciary. Commentators from the PRC describe this as an error which exists in common law systems, this idea of independence of the judiciary. The judiciary in the PRC should serve the interests of the Chinese Communist Party. Professor Yash Gai, eminent professor from Hong Kong U, gives the opinion that the key theme of the basic law is continuity. So I want you to think about that as a key theme, that things will basically remain unchanged. Don't worry, said Deng Xiaoping, don't worry, things are going to be just as they were, pretty much. You're going to have the same legal system, the same judges, etc., etc. So, Hong Kong got to keep its common law system, its independent judges, its jury system, and its courts, more or less. slight changes to the courts because we had to have a new final appeal court, but other than that, the court's pretty much the same as before. Article 8. This article, I would suggest, remains the backbone of Hong Kong's special position as a common law system. And it states, the laws previously in force shall remain in force, except for any that contravene this basic law or are replaced by local legislation or have been changed by our Court of Final Appeal. So only in those three situations. So those laws which were in place on the 30th of June 1997, primarily the English common law rules as applied by the Hong Kong courts, remain operative. They shall be maintained unless they were held to be in conflict with the basic law. This happened in one or two cases. For example, when Hong Kong introduced a Bill of Rights, it was said that it would have a special status over other laws. This was held to be contrary to the basic law because the only law with a special status is the basic law itself. But aside from that, and a few others, most of the previous laws remained. Again, they would be maintained unless they were overturned by local legislation. So, for example, LegCo may say, this old common law rule is hereby extinguished. And then, implicitly, although it doesn't say so in the basic law, the Court of Final Appeal can overturn any of those previous rules because it is our final Court of Appeal. The same judges and courts. The following summary of relevant basic law articles shows that more or less Hong Kong has kept the same courts and judicial arrangements as before. The same judges. Article 92 says, judges and other members of the judiciary of the Hong Kong SAR shall be chosen on the basis of their judicial and professional qualities and may be recruited from other common law jurisdictions. So we don't even have to have Chinese-only judges. Two exceptions. The Chief Justice of the Court of Final Appeal must be a Chinese citizen who's lived in Hong Kong and has no right of abode anywhere else in the world. The Chief Judge of the High Court, that's the person in charge of the Court of Appeal, must also be a Chinese citizen with no right of abode everywhere else. Any other judicial role can be filled by someone from overseas. Doesn't happen, in fact, very often, but it's possible. Article 93, judges and other members of the judiciary serving in Hong Kong before the establishment of the Hong Kong SAR may all remain in employment and retain their seniority with pay, allowances, benefits and conditions of service no less favourable than before. That's significant, isn't it? You might think, oh, China's taking over in 1997, let's get rid of all those expat judges and so on. But no, the basic law says they can remain. And on the same pay and conditions. No pay cuts. I'll tell you why that was significant. 2003, we had the Asian financial crisis. Many of us, including me, had our pay cut by 10% because we were regarded as civil servants. But not the judges, because the basic law says you can't. They have to remain in position with at least as good pay and conditions as before. And the same independence. Article 19 says the Hong Kong SAR shall be vested with independent judicial power, including that of final adjudication. And Article 85 says the courts of the Hong Kong SAR shall exercise judicial power independently, free from any interference. Members of the judiciary shall be immune from legal action in the performance of their judicial functions. You can't, in other words, prosecute them for making the wrong decisions. It's very important to judicial independence that judges have security of tenure. Okay? They stay until retirement age, unless they misbehave, and that's very unusual. If they commit a criminal offence, you can get rid of them. But it's very difficult to get rid of the judges. You can't say, you know what, this guy's getting a bit old, he's making some stupid decisions. Very difficult to get rid of them. And that helps independence. Because if I'm a judge and I have to think, you know what, if I make an unpopular decision now, maybe I'll get thrown out next year. Doesn't happen. They have security of tenure, which assists their being independent. Article 89 says, a judge of the Court of the Hong Kong SAR region may only be removed for inability to discharge his or her duties, or for misbehaviour, by the Chief Executive on the recommendations of a tribunal appointed by the Chief Justice of the Court of Final Appeal, etc., consisting of not fewer than 3 local judges. In other words, big procedure, very difficult to get rid of a judge. And no judge since 1997 has ever been thrown out for incompetence or bad behaviour. So they're very safe in their job. Their job comes to an end on retirement age and not before. So, the same Hong Kong courts. The magistrates' courts were with us before, they're still here. The district court, the Court of First Instance, and the Court of Appeal. All of those were there before, although they had slightly different names. The Court of First Instance was called the High Court. Now the High Court encompasses the Court of First Instance and the Court of Appeal. But this is, you needn't worry about that. These are the present courts, and they're pretty much what we had before. The big change, of course, is that at the top used to be the Judicial Committee of the Privy Council in London, and now it's Hong Kong's Court of Final Appeal. It's the final appellate court, and only this is significantly different from before. So, the only big difference, the Court of Final Appeal. There it is, in Central. That building used to be the old LegCo building. And before that, it was the Supreme Court. So it was a court, then it stopped being a court, and now it's a court again. Nice building. When it was vacated by LegCo, which moved to Tamar, then the Chief Justice, Andrew Lee, says, oh, could we have it as our Court of Final Appeal? It would be just right. And sure enough, that's what happened. The Court of Final Appeal then, a 1997 creation after the handover. Article 81 of the Basic Law says, the judicial system previously practiced in Hong Kong shall be maintained, except for those changes consequent upon the establishment of the CFA. So everything else is going to be the same, except you've got a new final appeal court in Hong Kong, not in London. It replaced the Judicial Committee of the Privy Council as the final appeal court for Hong Kong, and is much busier. Back in the day, there weren't that many appeals to London. After all, just imagine the hassle of your case having to go all the way to London, how much more expensive it's going to be, how much longer it would take. Now, our Court of Final Appeal is much busier. When the Court of Final Appeal was formed, no Hong Kong judges had experience of being a final appeal judge, and this partly explains another change. Court of Final Appeal membership. Under Article 82, the power of final adjudication shall be vested in the Court of Final Appeal, which may, as required, invite judges from other common law jurisdictions to sit on the Court of Final Appeal. So to get that experience of final appeal courts, the Court of Final Appeal can, it doesn't have to, but it can ask an Australian judge or a British judge to sit as one of its 5 members. Notice I've said sic, that means thus, may invite judges. Originally it was thought, oh, they could ask 3 or 4 judges and there'd only be one Hong Kong. But the loyalist side said, no, 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 you can only have one each time. And even before the Basic Law came in, the Court of Final Appeal was actually created. The British liaison group, the Chinese liaison group actually agreed between themselves that although the rule, the Basic Law says judges, it will only be one judge per case. Okay? So the normal setup in our Court of Final Appeal is this. The Chief Justice will sit. There will be 3 local permanent judges and 1 non-permanent judge who may be from Hong Kong or from overseas. In the majority of cases, the overseas judge is still used. Again, the Chief Justice, like the Chief Judge of the High Court, must be a Chinese national with no right of abode elsewhere. Permanent judges can be Chinese or foreign, must have worked in Hong Kong as a judge in the Court of First Instance or Court of Appeal, or as a barrister for 10 years. Non-permanent judges can be overseas or local, and their use is at the discretion of the Chief Justice. Should we have a local non-permanent judge this time or an overseas one? A word on the overseas non-permanent judges, a very important function. There is the power then to invite overseas judges. It's clear, it's laid down in Article 82. They provide a vital link between Hong Kong and the rest of the common law world. So what I'm trying to stress is Hong Kong remains part of the common law fraternity. You saw that on the map. And to help keep it in touch, we use the overseas judges. They can say, you know what, this is what we're doing in the UK at the moment. You might want to consider it, you know, that kind of thing. Or the Australian judge will say, you know what, this is what we do there. Hong Kong's a small jurisdiction. Australia is bigger. England is much bigger. So, all those overseas non-permanent judges are required to be serving in or have served as a final appeal court judge elsewhere. Despite the clear benefits of overseas common law experience, loyalists continue to complain about parachute judges who don't understand Hong Kong. Nonetheless, it is important to have that experience. Chinese proceedings in the court. I've said that it's all about continuity and no change. This is a big change. It didn't start with 1997, but frankly, the British left this too late. We now we can use English or Chinese. They're both official languages. They can be used in the courts. This is particularly the case in the lowest of the criminal case courts, not an appeal court, but where most cases are heard, the magistrates' courts. Previously, procedure was in English, and the poor defendant would usually be a Cantonese speaker who didn't really know what was going on. That's not a good system of law. This was changed. Now, under Article 9 of the Basic Law, in addition to the Chinese language, English may also be used. The advantages then of using Chinese, the magistrate and the judge can directly communicate with defendants in their own language. It's much fairer on the defendant in a criminal case. It renders the courtroom less formal, and it reduces the reliance on court interpreters. Previously, okay, the proceedings are in English, the judge was English speaking, and if he wanted to say anything to the defendant, he'd have to get the interpreter. Well, that's not a good system. And anyway, interpreters don't always get it 100% right. So now, Cantonese proceedings. In short, Hong Kong remains part of the common law brotherhood. It is generally bound to follow English common law, which was in place on the 30th of June 1997, subject to exceptions. And in practice, Even post-1997 English decisions are given great attention because Hong Kong law derives from the same traditions and tends to follow England's lead. So, after 1997, no decision in England can be binding in Hong Kong. The courts don't have to follow it. But in reality, they very often do, particularly if it's the UK Supreme Court, because it represents a very important source of English common law. The retention of the common law system is boosted by Article 84 of the Basic Law, which confirms that Hong Kong courts may refer to precedents of other common law jurisdictions. In other words, when they're reaching their decision, they can say, oh, let's look at a recent decision in Australia, which is relevant and was dealing with the same point, or a recent decision in UK. And of course, the other thing that keeps us in line with the common law is the overseas non-permanent judges. Now, I've said English common law. I need to emphasize this. You probably use the expression UK, don't you? Yeah? You would say, I come from the UK. If you're going to England on a vacation, you probably say, I'm going to the UK. It's pretty much Hong Kong shorthand. But actually, the law which Hong Kong has inherited is not the UK law. It is the English common law. Scotland, the other major country, doesn't even have a common law system. It has a largely civil law system, like France, Germany, etc. It's a bit common law and a bit civil law, but it's not. So in the Scottish criminal procedure is very different. Their criminal law is different, and they decide the final appeal on criminal matters. On civil, non-criminal matters, it's true, there's a final appeal to the UK Supreme Court. So Scotland is a bit half and half. So we do talk correctly about not UK common law, but English common law. So, wait a minute. I keep telling you Hong Kong's part of the common law system, but I haven't explained properly what the common law is. How are common law systems different from civil law ones? Now, this is very much legal system and very much something you would want to focus on. You'll learn much more about it, of course, if you do enroll on the CPE. So, what's the difference? The most important difference is that in common law systems, most of the law comes from decided cases. Does that mean Parliament legislation has no role? No. If there's something wrong with the common law, Parliament will pass legislation. If there are gaps in the common law, Parliament will pass legislation. If it is felt that there's not adequate consumer protection in the common law, Parliament will pass legislation. But basically, the law derives from judge-made law, case law. For example, I teach contract, I teach tort. During the course, I will probably refer in contract to maybe 2 or 3 pieces of legislation only. I'll deal with probably 500 or 600 cases. In tort, pretty much the same. Okay? So it's case law. It's based on judicial precedent, especially what we call binding precedent, which I'll explain in a moment. Legislation, known as ordinances in Hong Kong, play only a secondary role. Although they are higher in status, if there's a piece of legislation, an ordinance, you must follow that. It takes precedence over a legal decision, but most of the law comes from cases. Legislation fills in the gap in the common law and makes necessary improvements. Conversely, in the civil law systems, again, France, Germany, etc., case decisions are not binding, and the law is to be found in legislation. usually known as codes. French law, for example, is found in the Napoleonic Code, founded by Napoleon in the early 19th century. The civil law tradition then, how are we doing? The civil law tradition. Most civil law systems are now dominated by written codes. For example, the Napoleonic Code in France from 1804. In civil law, it's the codes, not the judges, which provide the law. Codes present themselves as a comprehensive source of law in a particular field, intended to shield against arbitrary judicial decisions. We can't trust the judges, they're not reliable, they change their mind, etc. Okay? The source in civil law is the codes. And they guarantee the separation of powers, that judges just apply law, but the state or the government makes the law. So, famous legal philosopher de Montesquieu, in The Spirit of Law, said, "The national judges are no more than the mouth that pronounces the words of the law, mere passive beings, incapable of moderating either its force or rigor." In other words, they're not important. They just tell you what the law is, but what the law is found in the code. That's the big difference between civil law systems and common law systems. Common law works on the basis of judicial precedent. The key features: a doctrine of stare decisis, binding precedent. This means, as I'll explain again in a moment, that if you're sitting in a lower court and you're dealing with a point that's previously been decided in a higher court, you must, not may, should, must follow what that higher court said. It's binding precedent. Stare decisis, this Latin expression, means stand by those things that have been decided. Don't change them. Vertical stare decisis means that lower courts must follow higher courts. Horizontal means that, for example, the Court of Appeal will usually follow its own previous precedents, but doesn't have to. Our Court of Final Appeal will usually follow its own previous precedents, but doesn't have to. In practice, it's never chosen to overturn one of its own. The idea is that this produces certainty. We know where we are because the Court of Final Appeal has said this, and that's the law for Hong Kong. A comprehensive analysis of the present position was performed by the then Chief Justice Andrew Lee in a case called A Solicitor and the Law Society of Hong Kong, a key Hong Kong legal system case. So when you study, if you study Hong Kong legal system in the CPE, you will learn about this case. It is the most important constitutional stroke legal system case in Hong Kong. Must follow precedents. For convenience, we often talk about lower courts having to follow the decisions of higher courts. But actually, decisions are not important. So, if you sue her in a court, we decide that you've won and she's lost. That's the decision. But how does that help later courts? It doesn't. It's just a decision. What is important is the reason for the decision, why we reach that decision, the legal reason for a decision. And that is known by another bit of Latin, the ratio decidendi. And if you study legal system, you have to get used to finding what the ratio decidendi is of a court. So this is the principle of precedent, that the reason for the decision of a higher court must be followed by a lower court if it is dealing with the same legal principle. So the rule is that the ratio of a higher court must be followed by a lower court when dealing with a case involving the same legal principle. A simple example. If a higher court establishes that the manufacturer of food or drink owes a duty to the consumers of such products to manufacture them carefully, that principle must be followed by a later lower court, also dealing with analogous manufacture and consumer case. This is supposed to produce certainty in the law because the highest court has said this, it must be the law and it has to be followed. Is that a bit rigid? No, because those highest courts can change their minds. They don't like to. They will do it, as Andrew Lee said, with great circumspection, but they can. So if eventually our Court of Final Appeal decides, you know what, we got it wrong 10 years ago, and this is causing harm to the law, they can then announce, we will no longer follow our previous precedent, and the law is changed. But we do that as rarely as possible because we want to keep certainty in the law. So the key requirements for precedent. If a lower court has to follow precedents of a higher court, there must be a clear hierarchy of the courts. They've got to be ranked so we know that this is lower than that. And secondly, there has to be full and accurate law reports so that the judge in the lower court can actually read what the higher court has said. Of course, you'd say, well, that's obvious. But 100 years ago in England, we didn't have official reports. You would sit in the courtroom and make a report, and you'd make a report. They might not even be the same. And so there was confusion in the law. But today, we have full and accurate law reports and a hierarchy of the courts. Here's the Hong Kong court structure today. At the top, the Court of Final Appeal. Every court under that must follow the decisions, strictly the rationes, the reason for the decision of that court when they're dealing with the same point. If there isn't a Court of Final decision, the lower courts must follow the Court of Appeal. The Court of First Instance only may have a little bit of precedent weight if it's dealing as an appeal court, but frankly, we're still not sure of that point. All the lower courts have no precedent weight. District Court, for example, you're a district court judge, you make a decision, she's a district court judge, next week she makes a different decision because these have no precedent weight. Only the top two and maybe the third have any precedent weight. A quick word on this court, the Judicial Committee of the Privy Council, because it's still important from Hong Kong. You remember I told you that before the Court of Final Appeal, the Final Appeal Court was in London. So, to maintain continuity, what Andrew Lee said in the A Solicitor case is, where there was an appeal from the Hong Kong courts to the Judicial Committee of the Privy Council before 1997, that must still be followed. That precedent must be followed by the Hong Kong courts, except the Court of Final Appeal. Only the Court of Final Appeal can change a previous Privy Council decision on appeal from Hong Kong. So, in the A Solicitor case, the Chief Justice, Andrew Lee, announced the Privy Council judgments on appeal from Hong Kong would continue to be binding on all Hong Kong courts except the Court of Final Appeal. So today, a Hong Kong court dealing with an issue would first ask, is there relevant legislation? Is there an ordinance? And if the answer is yes, you must follow that. If not, is there a relevant Court of Final Appeal decision which is relevant? If not, is there a relevant Judicial Committee of the Privy Council on appeal from Hong Kong on this? And if not, is there any relevant case from the Court of Appeal, and what is their status? The common law and the related doctrine of precedent are therefore hugely significant for Hong Kong. But, strange but true, we almost didn't get the English common law because this man, Captain Elliot, you'll probably know a bit of the history. After the Opium War, Britain took Hong Kong. Captain Elliot was sent, you're going to be what was called the plenipotentiary, the man with full powers to run Hong Kong. He ran up the British flag and announced all Chinese citizens in Hong Kong will continue to follow imperial Chinese law. But the British and other Europeans, non-Chinese, will be subject to English law. A dual system, not the common law at all. However, this didn't last for long. The Foreign Secretary, Lord Palmerston, didn't like Captain Elliot because Captain Elliot was against the opium trade, called him back to England, and within a few years, this dual system had been effectively abolished. And the rule was, you will follow the English common law unless it's unsuitable for Hong Kong. So again, we nearly didn't have the common law, but Captain Elliot's short-lived experiment of a dual system did not last more than a couple of years. Lastly, the limits of the common law in Hong Kong. I don't want to get political, but of course, so far I've tried to suggest to you that the common law is in Hong Kong, it remains in Hong Kong, nothing has changed. But that would be a slight exaggeration. So, although I've described the Hong Kong to you as a predominantly common law system, deriving from case law, the Court of Final Appeal is at the top, there are other non-common law sources of Hong Kong law which are becoming increasingly important. For example, PRC legislation. It was once the case that the really only important piece of PRC legislation was the basic law itself. But now, of course, we have a very important piece of legislation, the national security law, a little bit vague, a little bit uncertain, but nonetheless a very important and far-reaching piece of legislation. Hong Kong has followed with its own piece of anti-treason, anti-subversion, etc. legislation known as the Article 23 legislation. These constitutional landmarks, however, are for discussion another time. Okay, we've got a little time for questions. Does anyone want to ask me anything on what I've said so far? Or are you going to sleep? Anything you didn't understand, or anything you'd like me to repeat, emphasize? No? Okay. In which case, notice then QR code and how and where to apply. I'll just disclose a little bit of bias. For over 20 years, I ran the CPE course at SPACE. I introduced the link with Manchester, where I previously taught, a very successful partnership, and a course with very high success rate in terms of progression from CPE to the PCLL, especially at Hong Kong U. So I'm not going to tell you in detail about it because since I ran it, I'm sure things have changed a bit and I don't want to misinform you. What you do, if you want to find out more, is to contact the program team. There's a hotline whereby you can do that. And you've got the QR there. So, thanks all.